Hello and welcome to the Herrington Carmichael Employment Law Update for May 2018. My name's Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got the 4 key topics in the last month for you from the wonderful world of employment law. So where do we start? We start with the issue of shared parental pay. In the last month we've had the case of Capita and Ali, which tells us that where an employee is in receipt of shared parental pay, there is no obligation on the employer to uplift that to the same level as maternity pay. This is on the basis that a shared parental leave pay is a benefit which is divided between mother and father, and therefore the correct comparator in relation to a discrimination case on shared parental pay is actually the mother in a situation and not the father. It removes the sex element in relation to that claim, and it appears to be a good decision, although there are some ramifications which we may see developing in relation to indirect sex discrimination, and that is one-to-one. Next is the case of Abril and Nottingham City Council. This case relates to a situation where a section of employees did not agree to a change in contract. They remained silent. Although there was an objection by a trade union, there was no industrial action. And it was held that where there is silence, there is not deemed acceptance of the variation of contract. What this means for employers is where you are changing contracts, you either need to give notice or you need to get confirmation that the contractual change has been accepted. Don't just rely on the fact the employee remains silent or doesn't say anything about it. Third point, the case of Carreras and United First Partnership Research, which relates to provisions, criterions or practice in relation to disability discrimination claims. Where a PCP applies, that can give rise to an indirect discrimination claim or a failure to make reasonable adjustments. In this case, it was held that an expectation to work longer hours was a PCP and therefore could give rise to a claim. The mere fact it wasn't written down did not actually make any real tangible difference. The expectation was there, that was the PCP, and that gave rise to the claim. Final case that I have for you this week is the case of Newcastle upon Tyne NHS Foundation and Hayward. This case relates to the giving of notice in relation to the termination of employment. It's good law, and it's a repetition of good law, that notice is only actually received at the point it's actually received by the employee. So if an employer wants to give notice to an employee, they have to make sure that that is received. So simply sending it in itself is not sufficient. You have to make sure it's received. And in this case, it related to a pension benefit that was enhanced based on the age of the individual. And because the notice was delayed, because it wasn't received correctly, the individual actually got a much greater enhanced pension benefit. Now, in most cases, that's not going to be a problem, but in particular cases, you're going to want to make sure the employee actually receives the notice correctly. That's it from me this month. I'll be back in June, and until then, best wishes. Thank you.